Good morning, all environment interest citizens and activists, lawyers. I'm very happy to welcome you to today's event on climate rights hosted by the Vienna-based ÖKOBÜRO, Alliance of the Austrian Environmental Movement, and the European Justice and Environment Network. And I want to talk a little bit from my personal experience with climate litigation and provide you some information on that. When I attended Vienna and also law school in the 1990s, I could see a lot of hope and promising developments regarding sustainable development and climate change. In this time, also ÖKOBÜRO was founded in 1993. This was in the aftermath of the 1992 United Nations Conference on Environment and Development in Rio, the Rio Conference in Brazil. As many of you know, the outcomes of the Rio Conference are still relevant today. And there are two particular concrete outcomes of the Rio Conference. The United Nations Framework Convention on Climate Change and the Convention on Biodiversity. Both items are highly politically and legally relevant for today's discussions and politics. However, my understanding in the 1990s was that there was a way to go in environmental and climate policy, but we can and we will make it. Make it to change our path of action to a sustainable manner. So I had a lot of hope, among others, in the Kyoto Protocol that was agreed in 1997 and in the Aarhus Convention of the United Nations ECE on public participation that was agreed in 1998. Now, some 30 years later, I can see a lot of progress in sustainable development compared to 1992, but the pace is far too slow. And we are not only too slow, we are heading towards a disaster. We are at the edge of a precipice regarding the climate and biodiversity crisis. It is far more likely we, meaning us, global citizens, find ourselves in a burning planet with only a fraction of today's biodiversity in 50 years than any other scenario. And this would impact all our now and future lives. Worst hit would be the poorest and most vulnerable people and countries. But severely affected would be all of us, the environment, species, individuals. So my hope was, as for the NGOs, that we could contribute far more with the Aarhus Convention against climate change and biodiversity loss. We made some progress, but too little, too slow. Thus, if we lack both effective climate legislation and access to justice rights, we need to develop further instruments to become more effective. And since quite some time, we are at the point where we can see direct and immediate impact of climate crisis effects to concerned individuals, but also to future populations. It is therefore more than logical and consequent that climate litigation and climate justice became a relevant factor all over the world in order to raise pressure on politics and legislation, not only, but also by bringing the human rights regime closer to the environment and bring together environmental and climate justice. For all those reasons, I'm happy and motivated that ÖKOBÜRO and Justice and Environment can offer an update on recent developments in climate rights in today's event and discuss options and conclusions for future steps in order to enhance our fight to save our climate, to save this world's biodiversity and a future of our children's health and well-being. I want to thank you for attending this event, so many of you, and the following discussions. I want to thank Veronica Marholt and the ÖKOBÜRO team, as well as Justice and Environment for the preparatory work. And I want to thank in particular our speakers today, Michaela Krömer, Laura Ottikober, Kerto Birgit Anton, for the following contributions. In this sense, I wish you an interesting and inspiring morning.
Thank you, Thomas, for this very warm welcome. My name is Veronica Marholt. I am an environmental lawyer at ÖKOBÜRO, specializing, amongst other things, in climate law, and I'm very grateful to be part of this event today. I would also like to thank everyone participating, especially our speakers, who I will introduce in more detail later on. And my aim today for this presentation is to introduce the DAYS project, the EU-funded DAYS project, in the course of which today's event is happening, and also give a brief introduction into the topic of climate rights. And before I go into that, let me just try to share my screen with you. There we go. Oh my God. Excuse me. Perfect. Now we're talking. All right. After this small hiccup, let's get into my presentation. So today's event raises the question which climate rights our law offers. And in order to get into this question more, I first want to try to offer a brief definition of the term climate rights. So the concept of climate rights encompasses a range of rights and legal mechanisms related to climate change at the international, EU, but also the national level. And these rights and mechanisms aim to ensure climate justice, protect against the consequences of climate change, as well as engage governments, businesses, and also society as a whole. And in March 2023, ÖKOBÜRO conducted a survey to evaluate the Austrian population's awareness of those climate rights. Basically, 500 people between 16 and 75 were asked about the climate crisis and climate crisis related subjects in an online survey. And these questions related to personal concerns about climate change, whether climate change affected them personally, whether they were aware of their climate rights and how they could be exercised, and if they were actually willing to exercise these climate rights. So we drew a few conclusions from the results of this survey. And basically what we found out is that 7 out of 10 persons who were asked about the climate crisis were concerned about it, especially 16 to 19-year-olds, and also people who had received a high school diploma. Around 4 in 10 also consider themselves personally affected by the impacts of the climate crisis, with 16 to 29-year-olds and people with a high school diploma stating this more often than average. 2/3 also assume that their basic and human rights are affected by the effects and impact of the climate crisis. And even more, 18%, so almost a fifth of the population, are even sure about this. About half of the population would take legal action to enforce the affected fundamental human rights, especially 16 to 29-year-olds. But the vast majority, so 85% of the people asked, do not know where they could turn to enforce these affected rights. So even though legal action seems possible for a large part of the population, the how is a very big problem. Also, 3/4 are of the opinion that the government should take more measures to protect Austria and its population against the consequences of the climate crisis. So in all aspects, there is a clear divide from young to old. So the older the responses are, the less often they express strong agreements with the statement. And this tendency can also be seen in formal education. People without a high school diploma agree less strongly with the statements ranging from concern to expectations of the government than people with a high school diploma. So as I already stated, the huge problem here is that even though a lot of citizens would be ready to take legal action, it is very difficult for them to do so since they don't know which institutions to turn to. And in order to raise awareness about climate rights, 6 environmental NGOs from Austria, Bulgaria, Estonia, Hungary, Slovenia, and Spain, under the umbrella organizations Justice and Environment, have initiated the EU-funded DAYS project. And in the course of this project, they will conduct surveys, interviews, and offer national events to understand the public perception of climate rights and also discuss adaptation and rights. The project aims to influence EU and also national policies and is aiming to reach 24,000 citizens in the project countries and 24,000 more in other member states. And we also communicate these results and events through social media and online platforms. And at ÖKOBÜRO, 2 more events are planned within the DAYS project. But what are climate rights even? So climate rights include, but also go beyond traditional human rights that can only be enforced in courts, and also include mechanisms, for example, ombudsman institutions that enable individuals and organizations to protect their rights, as well as demand climate action and hold governments and businesses accountable for their potentially climate damaging behavior. The DAYS project aims to explore the practical application of climate rights, as well as to raise awareness among target groups and the general public as well. It also aims to test the readiness of target groups to exercise these rights and mobilize support for a generally stronger system of climate rights. So it is widely recognized that a clean, healthy, and in effect, functional environment is essential for the enjoyment of human rights, such as, for example, the right to life, health, food, or an adequate standard of living. And the Intergovernmental Panel on Climate Change has even highlighted the adverse effects of climate change on billions of people, ecosystems, natural resources, and infrastructure. These effects include, but aren't exclusive to, immediate threats to human lives, as well as long-term environmental degradation that undermines access to essential resources. International human rights law requires states to prevent climate harms and also regulate environmental practices, protect vulnerable communities, and also hold violators accountable for their actions. Meeting these obligations, however, would require stronger laws and effective regulation of the private sector, and also incentives for action, as well as protective measures. So the United Nations Framework Convention on Climate Change recognizes that climate change is a common concern of humankind, and the Paris Agreement also acknowledges the need to address the climate crisis while respecting and promoting human rights, including the rights of indigenous peoples, local communities, migrants, children, persons with disabilities, and generally people in more vulnerable positions. Gender equality and women's empowerment are also empathized. So which legal mechanisms are the most often instrumentalized as climate rights? So the first and most commonly known class of rights, category of rights, so to speak, are fundamental human rights. Constitutional rights related to environmental protection typically include several archetypes. For example, government's duty to protect the environment, substantive rights to environmental quality, as well as individual responsibilities to protect the environment. The Office of the High Commissioner for Human Rights identifies a lot of rights affected by climate change, such as, for example, the right to life, self-determination, development, food, water and sanitation, health, housing, education, meaningful and informed participation, the rights of affected communities, the rights of future generations, and gender equality. So that's quite a list. However, a right to healthy environment in itself is oftentimes not recognized in European constitutions. There are exceptions, but a lot of national constitutions include constitutional state objectives to protect the environment. For example, in Austria, it's paragraph 3 BVG Nachhaltigkeit, which are, however, usually not enforceable by the individual. However, there are human rights provisions that have been commonly used in an environmental context. For example, the European Convention on Human Rights and the case law of the European Court of Human Rights play a significant role in addressing climate-related human rights issues. The European Court of Human Rights has, for example, recognized the obligations of states to protect the right to life and take appropriate measures when there is a concrete and immediate danger. It has also acknowledged positive obligations of states to safeguard the rights to privacy and family, including protection from environmental hazards. Climate-related property rights can also be invoked when certain properties are affected by the impacts of climate crisis. However, the state's duty to protect human rights often depends on the measures that affected individuals could reasonably expect, the gravity of the threat, and also the balance with other fundamental rights. However, fundamental human rights are among the most promising climate rights and have been successfully exercised before national courts, for example, with the progressive Klimabeschluss of the Constitutional Court. So the next, not as well known, I think, concept that can be instrumentalized for the exercise of climate rights is the concept of a just transition. This concept aims to balance human welfare, job preservation, and the need for decarbonization. It emerged in the 1970s as a demand from trade unions for an environmentally sustainable transformation that ensures social justice. And this is because the transition to a low carbon economy can impact workers both positively, for example, through the creation of new jobs in renewable energy, and as well as negatively through job losses in the fossil fuel industries. And the International Labour Organization recognizes the importance of a just transition and paying attention to that factor, and the creation of decent work in environmentally sustainable economies. And just transition rights are in the end often exercised in the form of challenges to a work contract termination to assess whether termination happened for climate crisis related reasons, or challenges to plans and programs governing the energy transition. And generally, most of these lawsuits are most common in Middle and South America. So when it comes to the domestic enforcement of climate goals, governments at a national as well as subnational levels have committed to addressing the climate crisis through international agreements and policy declarations. For example, the United Nations Framework Convention on Climate Change, its Kyoto Protocol, as well as the Paris Agreement serve as very important international agreements in that respect. And in order to implement these commitments, governments enact national laws, or at least they're supposed to enact national laws and regulations that limit greenhouse gas emissions especially in specific economic sectors. However, this exposes them to legal actions challenging these commitments if the commitments are considered too lax by litigants, especially since sanction mechanisms to international agreements are often not very strong or even non-existent. And this is why litigants have made efforts in the past to find national ways of enforcing international climate goals. However, this depends largely on the role of international law in the respective national countries, and claims are often tied to other human rights violations in general. Moving from public and international law into civil and private law, increasingly corporations are also being targeted through climate change litigation. With a small number of enterprises being responsible for a significant portion of global emissions, claimants want to hold corporations accountable for climate damaging actions in general. The most common claims are based on tort law, so classic Schadenersatzrecht, including nuisance, negligence, strict liability, and also civil conspiracy. Claims, alternatively, might also be based on unjust enrichment, as well as consumer protection. And also shareholders are becoming more important actors when they bring legal actions against companies in which they themselves hold shares. So examples of such corporate climate change litigations might include, for example, tort law claims, which are lawsuits alleging public nuisance or defective products, which have all been filed against corporations, with fossil fuels often being the focus of those claims. As a second point, we can also mention unjust enrichment claims, where claimants argue that corporations benefit from the production and sale of fossil fuels, while also avoiding at the same time the cost associated with reducing their impacts. Consumer protection claims are also becoming more popular, with claimants alleging that corporations engage in deceptive marketing or greenwashing, and thus misleading consumers about the environmental impact of their products. And last but not least, shareholders are also taking legal action against companies for failing to disclose climate risks, or even misleading shareholders by failing to disclose said risks. And I think a nice example for such a tort law-based claim is the RWE case, which illustrates the intersection of the climate crisis litigation and corporate responsibility really well, I think. Basically, a Peruvian farmer filed a complaint against RWE, which is a German energy company. And the Peruvian farmer claimed that his home was threatened by glacial retreat caused by global warming. So basically, his home was located near a lake, and the lake was located near a glacier. Glacier was melting, water levels were rising in the lake, and the farmer feared that his home and property were going to be affected by that flooding, and asked for the return of damages. The case was, unfortunately dismissed in a German court, but an appeal has been filed, and this appeal has also been highlighting the ongoing nature of climate change litigation, which doesn't seem to disappear anytime soon. So since the Paris Agreement of 2015 requires countries to keep global temperature rise to less than 2 degrees Celsius above pre-industrial levels, and to pursue efforts to limit the temperature increase of 1.5 degrees Celsius, this is probably not going to be sufficient to avoid all the negative effects that the climate crisis might potentially have. Because even if greenhouse gas emissions are stopped relatively soon and we reach a point of net zero, global warming and its effects will last many years because they're already there due to the inertia of the climate system. So both carbon neutrality and adaptation will be necessary. The global goal on adaptation was also established under the Paris Agreement. It also focuses on supporting long-term adaptation goals of parties and funding support for especially most vulnerable countries' adaptation needs in the context of the Paris temperature goals. Basically, this global goal on adaptation features three core components. First of all, reducing vulnerability to climate change. Secondly, enhancing adaptive capacity, so capacity to adapt to the effects of climate change, and also strengthening resilience. Climate change litigation is thus expanding to include claims related to the rights to proper climate change adaptation. And these rights are also based on human rights. Basically, that's the obligation of states to actively safeguard fundamental rights. And this is why failure to take necessary adaptation methods or measures can also be challenged in court, or should be able to challenge in court, be challenged in court. Very important in the context of climate rights are also procedural rights, since they are kind of, they play a crucial role in realizing substantive rights to realize material rights, including those related to climate crisis. These rights provide opportunities for individuals to access state authorities and institutions, and also aim to ensure transparency and control over state power. Procedural rights include, for example, the access to right to information, participation, and access to justice. And these rights are also essential for effective climate governance. The Aarhus Convention on access to information, public participation in decision-making, and access to justice in environmental matters, as well as national laws across the UNECE regions and EU member states, recognize procedural rights. Especially the convention guarantees access to environmental information, participation in decision-making, and access to justice. It also aims to protect the right of every person to live in an environment adequate for their health and well-being. These rights are fundamental to both environmental and climate justice, and also international climate corporations such as the Paris Agreement recognize the importance of procedural rights for strengthening climate action. As a last point, EIA and SEA procedures can also serve as mechanisms towards a more climate just policy making. For example, environmental assessment procedures, such as those resulting from the Environmental Impact Assessment and Strategic Environmental Assessment Directive, also involve procedural rights relevant to climate change. For example, the EIA directive ensures public involvement in protecting the environment, also including the climate, from the impacts of specific projects. It requires effective public participation in decision-making procedures, and also the consideration of public consultation results. It also emphasizes the assessment of direct and indirect effects on factors such as human health, land, soil, water, as well as the climate. It also might be able to take climate change into account when determining whether a project should undergo environmental impact assessments. The SEA directive, on the other hand, aims to integrate environmental consideration into the preparation of plans and programs, so one level higher than the specific project even, and also can contribute to sustainable development. It does not explicitly refer to the climate crisis. However, the SEA directive also requires the assessment of significant effects on human health, and the SEA report must also consider effects on biodiversity, for example, as well as population, and other environmental factors such as flora, fauna, water, air, etc. Recent court cases have also highlighted the importance of considering climate change impacts in such environmental assessment procedures. For example, the Chilean Supreme Court ruled that climate change should be taken into account during the environmental impact assessment process for a project's environmental permit. So all in all, we can see that a variety of legal mechanisms can be used as climate rights. However, it is still not common practice to do so in a lot of national legislations, and national courts are oftentimes also hesitant to make progressive decisions in that regard. However, there are also positive examples like the Agenda case and the German Klimabeschluss that enforcing climate rights can be a viable way to demand climate justice from responsible authorities. And there is a large variety of claims that is currently being brought before courts based upon very different lines of argumentation, some of which we will hear from today. I am very honored to welcome 3 speakers who were all involved in the submission of climate cases to their respective national courts, and are also absolute experts in the field of climate litigation. Michaela Krömer, Laura Otipkova, and Kertu Birgit Anton. So starting off with an Austrian example, Michaela Krömer is an attorney at law at Krömer Law Firm and the founder of the NGO CLAW, Initiative for Climate Law. She also holds a Fundamental Rights Award of the German League for Human Rights and initiated 2 climate lawsuits before the Austrian Constitutional Court and also before the European Court of Human Rights. Welcome, Michaela Krömer. Thank you all for your attention, and I'll hand the presentation over to you. Thank you.
Hello, a warm welcome from my side. I'd like to build on Veronica's presentation in more practical terms. And I actually have to ask Veronica to please share my slide because for some reason my laptop doesn't allow me. I think I have too much of privacy preferences going on here. So okay. I do apologize for that. I have tried to make it work. So basically, I'm going to talk about 3 climate cases, 2 of which are still pending and 1 has been decided. The overall theme that we have when it comes to climate crisis litigation in Austria is the fact that we do have a protection deficit. Put simply, that means that rights you might have in theory, fundamental human rights or other constitutional rights, cannot be enforced with regards to the climate crisis because there is no complaint mechanism available. So there is an issue of standing, which is the main hurdle that we face. And you will see that running through. This is the current theme of these 3 cases. And I'm going to start with the first package, which is basically 2 cases that belong together. And next slide, please. So in order to demand a more progressive jurisprudence, which Veronica has mentioned, and sort of encourage the courts, as I always put it, to stretch, using the example of yoga, meaning that there are certain positions courts have taken, and in order to provide effective protection with regards to these prices, they just need to stretch them a bit further. We're not asking them to take on a completely new position. So anyway, in order to encourage quite conservative courts to stretch, you need a really good fact pattern to try that. And I'm actually convinced, I'm not that confident, but in this regard I am, that we do have a quite good fact pattern when it comes to a human rights case and the protection deficit. And this is this brave young man, his name is Max. Max suffers from multiple sclerosis. And with 60 to 80% of people who have MS, and actually a lot of other illnesses, the symptoms of disease worsen with the increase of temperature. That means, put practically, that when it's about 25 degrees Celsius, Max, as you can see on the picture, has to sit in a wheelchair. Once it gets even hotter, so you're reaching about a temperature of about 30 degrees Celsius, he can't push the wheelchair by himself because of lack in a muscular arm strength. So he loses the ability to actually push the wheelchair. So the fact that it's continuously getting warmer and hotter, and is already now, compared to when he was born, there is a causal link between the climate crisis and his family and private life, his personal life, his well-being. So he arguably has a case under Article 8 of the European Convention of Human Rights. If you have an arguable claim to make, very logically, the European Convention of Human Rights says, well, you have to have a right to an effective remedy. If you have a plausible claim, you have to be able to make that heard and to actually have courts decide on the merits. And if you, next slide, please. Thank you so much. So the issue is that, as I said, in Austria, he actually doesn't have a remedy available. This is mainly due to the fact that our Climate Protection Act doesn't provide for a complaint mechanism. And if there is no way through the Climate Protection Act, there is no actual overall duty of states to act and protect that you can adhere to in the Constitution. So the inaction of the state cannot be challenged, and the inaction, the non-compliance with the Paris Accord or other agreements, that is the main issue when it comes to the climate crisis. We are in the position that we're in because states are not doing what they should be doing. And given the fact that he doesn't have any type of remedy available, he doesn't have a chance to directly adhere to the constitutional courts, making the claim that, well, there is an Article 8 case to be made, he could theoretically have gone straight to the European Court of Human Rights. And yet we all know that the European Court says, well, you have to try everything nationally possible in order before you come and sort of speak to us, which makes complete sense. So you could have said to the court, the European Court of Human Rights, well, there is no way for me to actually make an argument. I just have to go directly to you because there is no meaningful remedy available, because the inaction cannot be challenged and the Climate Protection Act doesn't allow me to do anything, neither does the Constitution. So as you can see from this slide, this is not the path and the strategy that I've taken. And actually this case was filed together with ÖKOBÜRO. I just want to thank at this point very much for the support. And we spent hours discussing what to do. And so we came up with the fact that, well, if you cannot challenge the inaction, we can basically challenge bad action, because at the end of the day, climate policy is a sum of action. And hence we were looking at climate damaging subsidies and requested the invalidation of those. This would be the only viable route that could have been taken. And in order to make an awareness and draw an awareness to the protection deficit that we have, we made it openly to the public to join MEX in this proceeding. The main idea was that there are tax privileges given to the aviation sector and not to the railway sector, although the aviation sector is the most damaging means of transportation. So there's a clear preference, and that preference is not justified by the tax system as well. It's basically a decision made by the state to give a preference to aviation as opposed to the railways. Now, I'm not going to go into all the technical details of how to challenge a norm, because it's very technical. And the main hurdle and issue of standing that we have in Austria, and I'll come back to that again in another case, is that only persons who are addressees of a norm can challenge a norm, because the court says only those who are addressed by the norm are the ones that can make an argument that their rights are infringed through that particular norm. That means you are dependent on the design of a norm. The argument that we made here, that stretch that we were asking the court to do, is to say, well, especially VAT taxes are recognized as consumer taxes, and they are all consumers here. They are the ones who have to pay the tax when they're using the trains as opposed to the planes, and hence they should be granted standing and be heard on the merits. Next slide, please. These are the legal arguments we made. Basically, as Veronica said, constitutional rights and the European Convention of Human Rights, and we made a request for preliminary ruling. So we were sort of trying to shoot as much as possible to get something going. And next slide, that did not happen. The court's reaction was, frankly speaking, a little bit cynical and not quite solid in its argumentation, because the court said, well, if you're not willing to fly, then you are not considered as addressees of a norm, which is interesting because they're taking a subjective element, if you want to use something, as opposed to the objective element that they actually have established, namely, are you actually addressed by the norm directly or indirectly? So I think you can maybe draw the conclusion here that they weren't sure how to deal with it, and yet they didn't actually want to deal with that case. And as a side note, I actually filed 3 cases with the Constitutional Court, because as a reaction to that case, a year later, I filed another case on behalf of a female version of Max, a woman who suffers from MS, and she's flying and using the railways, if that's what the court, what the court needs in order to grant standing. It's not very logical, because people who are flying are privileged by the law, and usually you cannot challenge your own privilege. The court might decide on the case in June or in September, so I'm quite interested in how they're going to solve this now, because they were really bold in saying that, well, you kind of have to want to fly in order to be considered an addressee of the norm. Anyway, as you can see from this whole very technical debate, this is nowhere near an effective remedy for Max, a person who's already currently suffering by the consequences of the climate crisis. Next slide, please. So Max filed a petition with the European Court of Human Rights. It's the 3rd petition that has been filed. Currently, unfortunately, been put on hold. Don't ask me why. It's been filed 2 years ago. And basically, he argues on the basis of Article 8 and Article 13, right to health, if you want to put it that way, bluntly speaking, and right to an effective remedy. And sorry, there's one point I wanted to make that I lost. Let's go to the next slide. Yeah, we do also make an argument on the basis of Article 6, Article 2. I'm not going to go into that for time reasons, but maybe we can talk about this and during the discussions and the differences if you win on Article 6 and Article 13. Maybe I'm just going to draw that out here. Is if you win on an Article 13, which is a purely procedural argument, the court doesn't have to look into the merits and doesn't have to make a decision whether or not states have a duty to protect. And the court, the European Court of Human Rights, hasn't made a decision yet. So we're all waiting for a decision, because there were the first hearing of the Swiss elderly, and there's going to be another hearing in September of the Portuguese children. But basically what we're all waiting is, are human rights granting us any kind of protection when it comes to the climate crisis? And they can only do so if states have a duty to actively do what they can. One thing that is very important with the European Court of Human Rights is Article 34. You have to make an argument that there is a specific victim here, that the petitioner that you have, that your client is very specifically impacted by the consequences of the climate crisis. The court at least has made in some statements already now had made it very clear that it's trying to stick to that jurisprudence, that it's not going to be an everyone's argument here. So you will be probably left, we will see, but you probably will be left with the fact that we do need brave victims to fight for more climate justice for all of us. I'm going to briefly run you through the Article 8 argument because it's similar to the Article 2 argument, just to give you an idea on how we did it and how most cases they have a very similar structure, because we also sort of exchanged on how to best do it. Please, next slide. So Veronica already mentioned there's a bunch of case law, and basically the case law of the courts so far said that under certain circumstances, states have a duty to protect when it comes to negative environmental impacts and also natural catastrophes. The stretch we are demanding from the court here is to say, well, the consequences of the climate crisis are a sum of negative environmental impacts and a sum of natural catastrophes. So pass pro toto, if you've done it in small, you should have to be able to make a decision when it comes to a sum of catastrophes that we're facing, that the states have to do something. Now, the big question is, when does the state's duty kick in and how do you determine that? And that's the type of argument I want to run you through. Next slide, please. There's a couple of tests, you can just put it all out there, a couple of tests that you have to fulfill. First and foremost is a certain threshold has to be met. So as I said in the beginning, you do have to have a really good case. I'm gonna show you in the next slide how we argue that threshold in more detail. Secondly, and that's a more easy argument to make 2023, is that the state has to know or ought to have known the danger situation that there is a protection arising from. And the third argument, unfortunately, that's also an argument that is easier to make given the fact that states are non-compliant with Paris agreements and any other type of climate goals that they're setting themselves, is the fact that are they setting appropriate measures here or not? And again, everything has to be looked on a sort of a living argument. The convention is a living instrument and has to adapt to the present in order to show its viability. And that's something that the court has numerously said, and that's an argument that's also been used. Next slide. So in order to pass the threshold test, in the case of Max, we got together with a couple of experts and developed an Uthoff impairment factor. Uthoff syndrome is the syndrome that says the symptoms of disease worsen with the increase of temperature. And so we've shown in the graph over time what it means for Max. And we have another graph that I haven't showed you here, but I'm gonna show you here, what that means for days and hours in his life. Because you do have so much data available showing you in great detail the temperature increase in the past, the projections for the future, that you can actually show to the court what it means for his personal and private life. Because if it's warmer, he either loses his ability to move, or he's locked in his home, all having obviously an impact on his personal and private life. So I think in this case, you can make the argument that the threshold test has been passed. Second slide, next slide, please. Next slide. Knowledge test, again, is a bit of an easy argument to make. One thing that most cases are still arguing is that the target should be to adhere to 1.5. Now, this is based on the fact that the IPCC is recognized as the best available science in the Paris Accord. And the Paris IPCC has already said numerous times that there's a huge difference between 1.5 and 2 degree warming. The problem here is that we all know that 1.5 is probably just out of reach. And so we can see that the moment climate climate litigation cases could potentially be successful because you can show an impact, are maybe a time when it's scientifically speaking too late. And it's really challenging, and I'm still struggling with what do you do with that as an attorney? Are you still trying to push for 1.5, even though you know it's a bit out of reach? Again, you never know. I mean, we all only know in hindsight what has been possible and what is possible. Or are you giving them the leeway of 2 Celsius, which we also know is very difficult target to reach? And so we were exchanging as attorneys filing the first cases on trying to be aligned. And we have agreed to 1.5 with all the limitations that I just mentioned. Also, Austria is one of the richest nations in the world. And so there is a different responsibility for Austria to adhere to climate targets as opposed to a developing country. And that is also written in the Paris Agreement. So the knowledge test is where the Paris Agreement basically comes in. And then the next slide, the due diligence requirement, just go through it. It's an easy argument to make because Austria's emissions are more or less the same as 1990. So you cannot say that they actually have made an effort to reduce emissions. And also, and I think there's one last point on the PowerPoint. Yeah. To protect wouldn't be competing with any other interests that Austria has economically and so for the socioeconomic protection of its citizens. One argument that is difficult to make in these cases is that you have to make an argument that it would be a difference for max if Austria adheres to its climate goals. You have to show in great detail that if one small state is actually doing what it can, it does make a difference for his life. And that's a difficult argument to make. It's usually solved saying that, well, everyone has different, we have shared responsibilities, it's a global problem, and it's only going to be solved if each and everyone lives up to their responsibilities. These responsibilities can be divided up quite clearly. And these are the measures and the standards that are set. And every reduction could potentially make a difference because we have the danger of tipping points where we actually don't know what is going to happen. So this is just superficial summary of this very complicated argument to make. This case, next slide, please. The Article 13 argument, I actually talked about it at length. The only thing I want to add on to that is to say that even if Max would have been successful before the Austrian Constitutional Court, and actually the Constitutional Court would have repealed climate damaging subsidies of the aviation sector, this wouldn't have solved his problem. So we really made the national proceeding to prove to the point to the court that there is no effective remedy available to him, and it should. This case is still pending, and I'm just going to briefly run you through the next slide, please. Through the last case, which is also about the protection deficit that we face in Austria. It's a case filed on behalf of 12 young children, youngsters and children. The case was filed in February and is most likely going to be heard in the next coming weeks, and we're waiting for the decision either this summer or in autumn. Next slide. In Austria, we do have the special situation that children have constitutional rights of their own. We do have a federal constitutional act on the rights of children, based on the Children's Convention Convention on Children's Rights. And actually, it's much stronger in its wording. It's very strong rights. And in particular, Article 1 grants children a subjective right to have their best interests protected. And also to intergenerational equity, which is very, very interesting. Article 34 of the Charter of Fundamental Rights of the European Union also seems to grant children subjective rights. At least that's what the literature says. Interestingly, even though we have this, we have had these rights since 2011, there hasn't been any case based on the federal constitutional act on the rights of children yet. So this is also the first case where we're trying this out, and also to try and get jurisprudence on under Article 24. We're also making an argument on the principle of equality that's similar to a line of argument that has been made in the German Klimabeschluss. Veronika already spoke about that, which basically means a fair burden sharing and the principle of objectivity. So these kids have strong rights, and the question again is, how on earth are they going to make the rights heard? Can they pass standing? Do they have a remedy available? And there is a similar game going on then with Max. Yes, they don't have a complaint mechanism available, and it's very difficult for them to actually try and get into a proceeding. Now, what would have been left to them, or is left to them, is trying to challenge norms that could infringe or do infringe their rights. They, again, next slide, please, have the same hurdle that Max has, that they are not addressees of the norm. The Climate Protection Act, which is an act that is at its heart dealing with intergenerational equity and the well-being of children now and foreseeable in the future, is not addressed to the children. The act is also very special because it doesn't have any reduction targets since 2021. It only says that there is a mere duty to negotiate, not to implement, and it has a retrospective orientation when it comes to emergency measures that need to be set. And these are the 3 points that the children are challenging, although they are not direct addressees of the norm. And the argument that they're making is that we are indirectly addressed by this norm and infringed in our rights because we have very strong rights which are not derived from the European Convention of Human Rights, which have not developed over time, but they were always set as genuine rights to be protected, also under the lens of intergenerational equity. And standing will be the biggest hurdle in this case, and we'll see if the court is going to deviate from its jurisprudence. It would potentially legally possible to deviate from its jurisprudence, but it, yes, does require the will to stretch. Next slide. And this is the last slide. There's a small type of advertisement here. Do excuse, climate litigations are difficult to file, but they're also really difficult to make them happen because of financial reasons. These cases have been possible because of CLAW. It's a small organization that is trying to change the law one litigation at a time, and has been able to fund especially the children's case. And I leave you with that, and thank you for your attention.
Thank you very much, Michaela, for this very interesting presentation of the several climate lawsuits that you have already filed. It's also good. I'm very excited for the verdict of the Austrian Constitutional Court that's supposed to reach us in summer or fall. And yeah, we'll see what happens if a progressive decision will be made. We're moving on with a presentation of a Czech climate lawsuit presented by Laura Otipkova. Laura is a lawyer at Frank Bold and joined Frank Bold in 2017 as part of the Responsible Energy team, which she has also led since 2021. Her main focus is climate protection and the energy transition from coal to clean and sustainable sources. Before that, she graduated from the Faculty of Law of Charles University, where she also received a PhD. And during her studies, she focused mainly on administrative and constitutional law. And she is also one of the authors of the Czech climate lawsuit. So the person who is by far best suited to present this case to us today. I'll hand over to you, Laura. Thank you for your presentation.
Thank you. Good morning to everyone, and thanks for the very nice introduction. I will now share my screen and share the presentation with you. Do you see the presentation? Okay, great. Thank you. So today I will be speaking about the Czech climate litigation, the case that we have launched in 2021. Here for just a brief overview where we are now in the case, and then I will start from the beginning and tell you everything about it. Currently, we are back at stage 1 because we had a favorable decision of the first instance court. Then it was quashed by the Supreme Administrative Court, and it was returned back to the first instance court for another hearing because the Supreme Administrative Court did not agree with the municipal court, but also said that maybe there are some other options how to decide. It is not clear whether the final decision should be positive or negative. Basically, the municipal court has to look at the case again and find some other decision, other justification. So we now have the option to adjust our argumentation and offer the municipal court something else to decide on than it did the first time. Just to introduce the case, it is a case organized by a civil association, which is called Klimatická žaloba, which means climate litigation in Czech. It is a civil association with over 300 members, maybe 400 now, and they are joined by other plaintiffs, which I will describe later. They have launched a website, a campaign. They have some representatives or faces of the campaign, including some celebrities. As Frank Bold, we provided the legal representation for them. Why the Czech Republic, such a small country, why to sue them? Because of climate change. At this picture, you can see that the Czech Republic has very high emissions per capita, actually the 18th highest in the world, which is more than, for example, China or these countries that we use to blame for climate change. So there's lots of space for adjustment or improvement in the Czech Republic in terms of CO2 emissions, and also the current policies are not ambitious enough to comply with the Paris Agreement targets. So this is why it is very important to have these climate lawsuits also in the small countries such as the Czech Republic. And in this picture, you can also see that the main source of CO2 emissions in the Czech Republic is the energy sector, because the Czech Republic is very fossil fuel dependent. That's also something we are working on in Frank Bold, besides the climate litigation. When we were launching the case, we were discovering various ways to approach it. As Veronica mentioned at the beginning in the presentation, there are multiple ways to approach the issue. You can have civil lawsuits or administrative lawsuits against states, against private companies. So what we chose in the end, based on sort of an analysis of all the options, what was an administrative lawsuit, challenging the omission of the ministries and the government in the Czech Republic. We have chosen several plaintiffs to have all the bases covered because we have the civil association, but under Czech law, the civil association only has the rights to a healthy environment, but does not have other human rights. So we added a municipality, and we are also basing the lawsuit on the right to self-governance, which I think is quite interesting. I'm looking forward to hearing what the court says about that. We have included landowners because of property protection, right to property. We have included a person with environmental anxiety and others who have their right to life and right to health protection also affected by climate change. So we sort of tried to assemble all the basic human rights that can be affected by climate change and have a representative of each of these. Initially, we argued that both mitigation and adaptation are a problem in the Czech Republic, which I still think that they are, but the courts were more inclined to accept the claims on mitigation And in adaptation, it is very much harder to quantify what's a good adaptation, because it's a very diverse topic and it covers lots of different areas. So the lawsuit is human rights based. We have included arguments about the case law of the European Court of Human Rights, Czech constitutional law, and also we tied these with the Paris Agreement and with Czech environmental law. The demands that we made were initially that the ministries in charge set up and maintain a carbon budget. I will explain how we got the carbon budget and what it means in a minute. And so that you can see the timeline, the lawsuit was filed in April. So it's more than 2 years ago now, and we still don't have the final decision. It has been a sort of ping pong between the courts, but hopefully we will get a decision, a new one soon. To elaborate on the demands by the plaintiffs, we have calculated a special carbon budget for the Czech Republic, because it is not only about the target for 2030 or about the target of climate neutrality for some time in the future, but you also need to look at how much CO2 emissions was emitted on the way to getting us to climate neutrality. The IPCC report also works with a global carbon budget, so we wanted to take the global carbon budget and say how much of that is the Czech Republic's responsibility. And we hired experts from the University of Manchester who counted this for us based on a method they have developed. They included the parameters from human rights law and Paris Agreement and national environmental law that all reflected in the carbon budget that we came up with. And we requested that the court orders the ministries to adopt adequate strategies and measures for adaptation as well, because we have climate change impacts really revealing in the Czech Republic all the time. It's drought, it's weather extremes, and those are also affecting people's rights. To show you the carbon budget specifically, you can see in this picture that the thing that matters is the surface under the curve. And you can see that the bigger gray area is what the Czech policies are planning for us, how much CO2 emissions are planned to be emitted in the Czech Republic until 2060, let's say. And then you can see the blue smaller area, and that is what is necessary to limit the emissions to, so that we can comply with the Paris Agreement. So this is what we submitted to the court. And in terms of climate change adaptation and the impacts of climate change, we had an analysis carried out by Climate Analytics. And you can see that this is a summary from the analysis showing different degrees of heating and its impact specifically on the Czech Republic, showing that if the temperature grows 2 degrees Celsius, then the impacts will be, for example, I don't know, excess deaths to heat will be 0.9% more than they would be if we kept global warming lower. Yeah. So this is what we also gave to the court as facts. And then we got the first judgment, which was favorable for us after 1 year of the proceedings. The court decided that the case is admissible, which was also a huge success for us, even that it was admissible for the ministries, not for the government as a whole, but that's okay with us. We just wanted to cover all the bases, so we submitted the lawsuit against both the government and the ministries. And then the court said that the obligations in terms of mitigation, they do exist. They are based on human rights and mostly the Paris Agreement, but only as far as the European shared targets to reduce CO2 emissions by 55% until 2030. So this is way less than what we requested. The court did not like the carbon budget. The court did not like our interpretation of the climate target that's in the Paris Agreement. And it only said that the European NDC, the national contribution, is binding on the state, which is still better than what the Czech government was planning. But it's not as good as what we wanted from the court. And in terms of adaptation, the court also said that there are some obligations, namely to adopt a strategy for adaptation. But since the ministries have formally adopted a strategy, even though it's not working in practice, the court says that it's okay because the ministries have a strategy, and that's all that matters. So that's quite formalistic from our point of view. So the court only ordered the ministries to reduce emissions by 55% until 2030, which was a great success, but not in all the requests that we filed. Then against the judgment, both the plaintiffs and the defendants filed their cassation complaints towards the Supreme Administrative Court. The plaintiffs wanted more ambition. As you can understand from what I just said, the plaintiffs wanted either a carbon budget or a goal with carbon neutrality included in that, because it does not suffice to only say that we need to do something until 2030, but we really need to go to the final line to climate neutrality. And also we disputed what the court said on adaptation. And the defendants, they also challenged the judgment, but from the other side, let's say, they challenged everything on the judgment that was unfavorable for us, even admissibility, saying that it's not even possible to file such complaint. And also they said that the mitigation ambition was too high, that 55% is too high. The Supreme Administrative Court issued an unfavorable judgment this February. They said that in terms of mitigation, it is incorrect that the Czech Republic should decrease the emissions by 55%. But the court did not say if the ambition should be higher or lower. It just said that the argumentation of the municipal court is incorrect. So we know this one way that it's not right, and we now need to look for other ways how to argue before the court so that it can decide in our favor. And it's not impossible to achieve a higher ambition in line with the Supreme Administrative Court's decision, but also it can be lower ambition or it can be no ambition. So the battle begins all new, I would say. The Supreme Administrative Court did not agree that there should be a climate neutrality goal, which is quite bad. It said that what we have in EU law is just very general, and it does not say how much activity is required from each EU member state, which is funny, because how much activity do you need to achieve climate neutrality, right? You need zero emissions, and 27 times zero is still zero. So yeah, I'm not sure about that. Yeah, and then also the court did not uphold our argumentation about the adaptation ambition. And in these terms, the adaptation branch of the lawsuit will not continue because it was rejected by both the courts. And now we are continuing only about the mitigation ambition. And the defendants, their argumentation about inadmissibility of the lawsuit was also not upheld, which is a very good message also for any other environmental NGOs wanting to sue the emissions of the government. And about the mitigation ambition, there will be the new proceedings. So we will see how it goes. The lessons learned that we drew from this case, it was very hard to find the plaintiffs. It took a lot of time because people are very scared that they would be showcased in the media, or we wanted to involve people who are in agriculture, but they were scared they wouldn't receive any subsidies from the state if they sue them. And in general, people are just very scared. It was great to have inspiration from other jurisdictions, and that's also very interesting for this webinar for me to hear about the other cases. The one that is, I think, most important for us is the German case, which also works with a carbon budget. But in the Czech Republic, we don't have a climate law, so that's worse for the Czech plaintiffs. That's quite paradoxical that the Czech plaintiffs do not even have a climate law to argue about, and the courts use it against us and say there's no legal obligation, so you cannot argue anything. Yeah, we had difficulties with the determination of the carbon budget because there are various methods, and all the methods lead to a very high ambition, but there's the ambiguity about the methods. It was also hard to get the expert authorities on board. In the end, the court listened to the IPCC reports the most, but did not take the other authorities that seriously as the IPCC, which is interesting to me. And also the court was very inclined to use EU law, which was also like a good message for me. And now this is the end of the presentation, and I'm looking forward to your questions, which will be at the end of the webinar, I think. So thank you for your attention and for coming to this webinar. Yeah, thanks.
Thank you, Laura, for this presentation. Very interesting to hear that Czech Republic also doesn't have a climate law, because in Austria, we do have one, but it hasn't been filled with new emission limits in some time. So very interesting to see that we share the same issue here. Next up, I'm very happy to also be able to present an activist perspective on climate litigation, because I do think that activists are a major driver in the environmental movement, and obviously also in climate litigation. Kertu Birgit Anton is an activist in the youth climate justice movement Fridays for Future Estonia. She is also one of the young complainants behind Estonia's first climate court case that is now pending before the Supreme Court of Estonia. And since earlier this year, she also works at the Estonian Environmental Law Center as a legal assistant and focuses mostly on climate issues. Thank you, Kertu, also for participating in today's event, and I'm very excited to hear about the Estonian climate lawsuit.
Thank you, Veronica, for this introduction, and hello to everyone. Good morning. I'll try to share my screen. I hope it works. There we go. I hope you can see the slides now. Yes, perfect. So my name is Kertu, and I'll have this dual perspective today that I can give on this lawsuit. As Veronica said, on the one hand, I'm an activist in Fridays for Future and a complainant behind this lawsuit. On the other hand, now for a few months, I've also worked at the Estonian Environmental Law Center, which is the center that is representing the young people in this case. Although, of course, personally, I'm not working on this case at the center. I'm working it up from this activist perspective. Anyway, to the case. So I'll go briefly over the timeline leading up to the case. So first, in 2019, the state-owned energy company Eesti Energia revealed the plans for a new shale oil plant. Then soon after, we held the first climate strike in Estonia, which at the time wasn't really linked to those plans, but they became closer linked later on. Then in August 2019, the first major step towards the construction of a new shale oil plant was taken. So the ministers approved of the detailed planning of the area of this industrial area of this new plant. and environmental organizations were very critical of it, but it didn't change anything much. Then that's an interesting point. In September 2019, the government of Estonia discussed whether or how to support the construction of this new shale oil plant. And they decided specifically to support the shale oil plant morally. And it was specifically said, not financially. And this became really important a few months later, when the government decided to allocate 125 million euros to the company to construct this plant. So in the end, moral support turned into money. And this, as you can remember, was during the first wave of the COVID pandemic, when everyone was at home, no demonstrations were allowed, and everyone's focus was elsewhere than on fighting a new bit of fossil fuel infrastructure. Then soon after, many environmental NGOs, scientists, young people urged the government to reverse its decision. Later on, there was also a popular petition sent to the parliament to reverse the decision. Different cultural players sent an open letter and so on. But it didn't really change anything. So in the end, okay, there is the one and most important bit has, oh no, now it came. So in the end, we as Fridays for Future Estonia submitted our petition to a court. Officially, the complainant is not Fridays for Future, it's an NGO called MTÜ Loodusvalu in Estonian, but it's just this official legal body of Fridays for Future in Estonia. And our petition is based on administrative law. So we went to court against the municipality of Narva-Jõesuu. It's a small municipality in northeastern Estonia, and they're the authority who granted the construction permit. And the third party who is very important in this case is Enefit Power, which is the state-owned it's a subsidiary of the state-owned energy company Eesti Energia, and they are the ones constructing this shale oil plant. As you can see, one of those they already have. It's in this picture, and they're going to, well, they're right now building one that looks exactly like this one. And our demand is to annul the construction permit so that they would not be allowed to build new fossil fuel infrastructure. So far, the case, as Veronica mentioned, is pending before the Supreme Court of Estonia. We lost at the first two stages, but honestly, it was quite expected, and we weren't too surprised because it is the first climate lawsuit in Estonia. And as far as we know, never before have the courts had to think about climate change seriously in, consider maybe fighting climate change should actually change a bit the way how we work as a society and what we construct and what we invest in. We have applied for interim legal protection 4 times because right now, although we are at court arguing against this construction permit, the construction is ongoing and the plant is nearly ready to start operation. Which, in the end might lead to the situation where perhaps the court even rules that the construction permit was granted unlawfully, but this does not mean that this plant does not start operating and producing new fossil fuels. But in May 2021, we actually were granted interim legal protection, and the construction was suspended for a few months, although, well, the construction hadn't quite begun, but at least it postponed the construction by some time. And the argument, the reason why we were granted this interim legal protection was that the company had not properly assessed the impacts on a nearby Natura 2000 area. This was, let's say, quickly fixed, and the interim legal protection was lifted, but at least it gave us some more time. And as I mentioned, the plant is nearly ready to start operating. Now, about our main arguments, mainly we have broadly we have 2 arguments. One of them is that the construction of this new fossil fuel production contradicts international agreements and EU law. So what makes it really difficult for us in Estonia is that we don't have a national climate law. So there is no law that states specifically the legal obligation for the country to reduce its greenhouse gas emissions. So we can only find support in international agreements and EU law, and this is what we have based on mostly. Although I'll mention that the climate law in Estonia is right now being prepared, but this doesn't really help us much at this stage. Then we also emphasize that the project, well, it is argued that the project is compatible with Estonia's national strategic planning documents, but those documents themselves are outdated. They are not compatible with the Paris Agreement and EU law. So the fact that the project is compatible with those documents doesn't really mean that it is compatible with international law, but it should be. And then, and this last point now has become really important, especially in the cassation process. The question is that what does the authority need to know and consider when they're granting the construction permit? So the other side is arguing that when granting the construction permit, the authority must only look at quite narrowly at the emissions and impacts that result from the construction of this plant, but not from the operation. But like in this case, the question is about a fossil fuel production plant. It doesn't have any other purpose than to produce fossil fuels. Then we think and argue that the impacts that result from the operation of this plant should also be considered. So far, the courts of lower instances have not agreed, but we're yet to see what the Supreme Court rules. And the second group of arguments relate to the fact that the environmental impacts of this project have not been thoroughly assessed. So they base, when the permit was granted, then it was based on a strategic impact assessment that was carried out earlier about this whole industrial area where they plan to construct 4 such plants. Right now they're constructing 1, but the plan was to construct 4, and then another refinery for refining this oil. And they claim that the strategic impact assessment was carried out with a precision equivalent to environmental impact assessment. We don't agree. We see that there are important shortcomings, and also that the scope of the assessment has been far too narrow. For example, that they haven't at all looked at the carbon emissions that result from the operation of this plant, and yet alone the impact that results from burning this oil that is produced in the plant, because that's also quite significant to note that the oil that is being produced in the plant will not be used in Estonia, at least most of it. It is meant for export to be used on long-distance ships on oceans. Then we also claim that the impacts on employment and health were not adequately assessed. And as I said earlier, the impacts on the nearby Natura 2000 area have not been thoroughly assessed either. And this was the reason why the court granted us interim legal protection. But then the third party, quite soon afterwards, submitted some further pieces of evidence, and the court ruled that, well, now it looks like there is no significant impact. And so what is really difficult, and what we try to argue against, is that the impact of this whole plant is sort of being salami sliced, so that they're looking at the impact of construction at one step, and then at the impact of the production of oil at the next step, so in the integrated environmental permit that we're also working on, but that's a separate procedure. And then they're looking, well, they say that the impact of burning this oil should be looked at yet another step. And so all in all, that makes the climate impact of this plant look much smaller than it actually is. And also what related to this environmental impact is the argument that we make that when Estonia exports its emissions, in this case in the form of this oil, then we need to look at this emission export. We just can't simply say that, you know, we export this oil, so the emissions that result from that are not our problem. But so far we haven't been able to convince the courts about that. So yes, right now we're in the cassation stage, and the main question has become that what does the authority need to know when they're granting this construction permit? Do they need to know the whole impact of the plant that is being constructed, or can they just make the decision based on what they know about the impact of the construction process, and all other impacts can be assessed later on? So this was about the first climate lawsuit in Estonia, and I hope we'll have a very interesting and fruitful discussion now later on. Thank you.
Thank you, Kertu, for this very interesting presentation as well, from also an activist perspective, and also how the whole lawsuit evolved. And generally, thanks to all speakers for presenting their respective national cases in such a accessible way as well.